Citizenship by naturalization. Naturalized citizens have most of the rights and privileges of native-born citizens. Congress has established qualifications for naturalization. Applicants must be of good moral character and have entered the United States legally. Applicants must read, write, and speak English. Applicants must show basic knowledge of American history and government and support the principles of American government. Steps to citizenship. An applicant must file a petition requesting citizenship, be at least 18 years old, have been a lawfully admitted resident alien for 30 months out of the previous 5 years, and have resided in the state for at least 3 months. At a final hearing, a federal judge administers the oath of allegiance to the new citizens. Losing citizenship. Only the federal government can take away citizenship. A person may lose citizenship voluntarily or involuntarily. The responsibilities of citizens. Responsible citizens need to know about the laws that govern society. Responsible citizens participate in political life. Section 3. The rights of the accused. Searches and seizures. The Constitution and the Bill of Rights protect the rights of accused persons. The Fourth Amendment offers protection from unreasonable searches and seizures, but the courts have dealt with this issue on a case-by-case basis. Today, most police searches are conducted with a court warrant. The 1914 exclusionary rule restricts the use of illegally obtained evidence. Supreme Court rulings in 1985 and 1987 limited the warrant requirement for legally stopped cars and for students and their property in school. In 1967, the Supreme Court reversed an earlier ruling permitting wiretapping. In 1968, Congress passed a statute requiring a court order before using wiretapping to obtain evidence. Guarantee of counsel. The Sixth Amendment guarantees a defendant the right to an attorney. In federal cases, courts generally provide an attorney for defendants who cannot afford one. State courts must also provide attorneys for defendants. Self-incrimination. The Fifth Amendment protects witnesses before grand juries and congressional investigating committees. The Fifth Amendment also protects defendants against forced confessions. The Escobedo 1964 and Miranda 1966 decisions expanded the protections of persons arrested as suspects in a criminal case. Double jeopardy. The Fifth Amendment protects accused persons from double jeopardy, or being tried twice for the same crime. A person may be tried more than once for the same act. However, when a crime violates both a federal and a state law. It is not double jeopardy if a single act involves more than one crime. A defendant may be tried for each offense. In the case of a hung jury, a second trial is not double jeopardy. Cruel and unusual punishment. The Eighth Amendment forbids cruel and unusual punishment. The use of the death penalty is an ongoing controversy under this amendment. Section 4. Equal protection of the law. The meaning of equal protection. Both the 14th Amendment and the 5th Amendment require that all people are entitled to equal rights and equal protection of the law. The Supreme Court has developed guidelines for deciding when state laws may violate the Equal Protection Clause. According to the rational basis test, the courts will uphold state laws that distinguish among different groups of people if the state shows good reason for those classifications. Classifications in state laws based on race, or national origin are suspect classification. The state must show some compelling public interest to justify them. State laws that violate fundamental rights, such as the right to vote and the First Amendment rights, are unconstitutional. Proving intent to discriminate. Discriminatory laws classify people solely because of their race, gender, ethnic group, age, physical disability, or religion. To prove a state or local government guilty of discrimination, one must prove the state's intent to discriminate. The struggle for equal rights. For nearly a century after the 14th Amendment was adopted, the courts upheld discrimination and segregation against African Americans. In Plessy v. Ferguson, 1896, the Supreme Court used the separate but equal doctrine to justify segregation in the United States. 58 years later, in Brown v. the Board of Education, the court overruled the separate but equal doctrine and touched off a long struggle to desegregate public schools. Civil rights workers peacefully broke laws supporting racial segregation. Protesters who were arrested and convicted then appealed, challenging the constitutionality of these laws in the courts. Influenced by the civil rights movement led by Martin Luther King Jr., Congress passed major civil rights legislation to ensure voting rights and equal job opportunities, such as the Civil Rights Act of 1964. Section 5. Challenges for Civil Liberties. Affirmative action. In the 1960s, the government began programs that gave a preference to minorities, women, or the physically challenged in hiring and promotions, government contracts, admission to schools, and training programs in other areas. Most affirmative action programs are required by federal government regulations or court decisions. Others are voluntary efforts. One of the most important applications of affirmative action is in higher education. In Bakke, 1978, and other cases, the Supreme Court has held that although a strict quota system is unconstitutional, a state university can consider race, along with other factors when admitting students. Outside of higher education, the constitutional status of affirmative action is unclear. The court has struck down as many programs as it has upheld. In 2014, the Supreme Court issued a ruling that allows state laws that ban affirmative action. New challenges against discrimination towards women have been raised. The Supreme Court held that past laws discriminating against women did not violate the Equal Protection Clause. In its ruling in Reed, 1971, however, the court held a state law was unconstitutional because it discriminated against women. Since the Reed case, the court has allowed some laws based on gender classification, but has declared others unconstitutional. Congress has passed many laws protecting women from discrimination. Citizens' right to know. The 1966 Freedom of Information Act requires federal agencies to grant people access to public records upon request, with some security exceptions. The Sunshine Act of 1976 requires federal agencies, boards, and commissions to hold meetings open to the public or to provide a complete record of the meeting. Citizens' right to privacy. The Constitution does not specifically mention privacy, but the Supreme Court ruled in Griswold v. Connecticut, 1965, that personal privacy is one of the rights protected by the Constitution. Widespread use of the Internet challenges the right to privacy because of such issues as online surveillance by the government and the availability of personal information on websites to hackers. War and other national emergencies create tension between the need to maintain individual rights and the need to protect the nation's security. The USA Patriot Act, passed in response to the September 11, 2001 terrorist attacks, greatly increased the federal government's power to detain, investigate, and prosecute people suspected of terrorism. Questions continue to arise over whether the act poses a threat to civil liberties.